Hello everyone, it's Mark. Welcome back. In this video I want to talk to you about the concept, the idea of the quote extended Baker Act. So I've been talking to a number of people recently who tell me that they were involuntarily taken to a Baker Act facility, and right before the 72-hour clock expired, when they should have either been released or the facility should file to keep them, the facility has told them they have quote extended their Baker Act. So I'm here to tell you that the sort of whole idea of a quote extended Baker Act, that is a term that has been made up by a Baker Act facility. It simply doesn't exist. There's nothing in the statute about, quote, an extended Baker Act. Okay, it doesn't work that way. Let me tell you how it works if you are there involuntarily, in other words, against your will. The facility has up to, not 4, but up to 72 hours to assess and stabilize you. Once the 72-hour clock has expired, one of two things need to happen. Either they need to let you go, or they need to file a petition with the court asking a judge for permission to keep you longer than 72 hours. And so once they file that petition, you're going to be held, you're allowed to be held until that hearing takes place. So in theory, you could be held another 3, 4, 5 days until the judge hears your case. But the whole idea that the facility gets to automatically or sort of on their own volition, quote, extend your Baker Act, that is a total for lack of a word, BS. It's simply not true. They don't have that authority. But because you were there and you don't have access to a lawyer and you don't know what's really going on, they tell you, oh, we've extended your Baker Act. It doesn't exist, and it's not right. And if you are having a loved one who is in a facility who's, quote, had their Baker Act, quote, extended, unless it was extended by a judge, we should talk, and we should talk quickly. With that said, thanks for tuning in. See you in the next video. Bye-bye.